what the intent of it is to go back. The state of Missouri is a employee at will state, and over the last 6 to 8 years, there have been a series of court decisions that have really eroded away our employers' rights. And so what the intent of this law is to restore what for decades were the commonly followed employment practices of the state. And so that is really the fundamental, from my perspective, the fundamental debate that we have, because the reality is, in my humble opinion, is that the economic climate of a state, whether employers want to be there, want to grow there, want to keep their jobs there or bring new jobs there, is directly related to how many things, many factors play into it, but clearly our tort system and the regulatory environment that a state has is at the forefront of all of those issues.
Individual managers and supervisors have never been individually liable under Title VII or the ADA. But in the Cooper case, the Court of Appeals held, yes, they can be. Senate Bill 852 is designed to eliminate that individual liability and make Missouri law similar to federal law. Motivating factor, as the senator has raised, has long been the law in federal court for over 40 years. That's the standard against which decisions have been measured for many years in the federal arena. The Missouri Supreme Court in recent years articulated a MAI jury instruction that has now watered the standard down to contributing factor. 852 is designed to merge the federal standard with the state standard, so we're all singing out of the same hymnal. Summary judgment is another issue that's addressed in 852. For many years, federal courts have used the vehicle of summary judgment to weed out what they've called factually weak cases. In Doherty, the Missouri Supreme Court, Doherty versus Maryland Heights, the Missouri Supreme Court essentially wrote summary judgment out of the law of Chapter 213. Senate Bill 852 is designed to restore summary judgment as a potential device for the courts to use to weed out factually insubstantial cases. Business judgment decision instruction is an instruction that has always been used in federal court, where a jury is told that they cannot rule for the plaintiff just because they disagree with the defendant's business judgment. In the McBride case, the Court of Appeals held that no, that's not a permissible jury instruction in the state of Missouri. 852 is designed to make sure that the jury instructions that are given in federal court and state court resemble one another.
Cognizant of my time, I want to address at least a question about the funding. I believe the argument that's going to be advanced is that the EEOC funding is tied to the law being the same as it is in Missouri. And in fact, these changes which deviate Missouri law from the federal law actually jeopardize the funding, not the other way around. So that's a misstatement. It's a misimpression that's been, I think, foisted here before. Likewise, I'd like to address the standard and the contributing factor standard and the question of the good senator to my right. It's not how much discrimination should we tolerate. It's what's the standard of proof to prove the violation of the statute, which is the claim. And Missouri and most states have always had a preponderance of the evidence standard. That is, it's more likely, the plaintiff has to show it's more likely than not that they can establish their cause, 51% to 49%. That's motivating factor. Contributing factor is, in my view, a seismic shift, not only in Missouri employment law, but in general common law in the state of Missouri, because it changes that standard. And that dovetails back into what I wanted to talk about, which was the at-will employment, because just last week the Missouri Supreme Court applied that contributing factor standard now to a wrongful discharge tort that is not part of the MHRA, although that would be part of these amendments, and that this amendment, proposed Senate Bill 852, would address. And likewise, we would get back to the preponderance of the evidence standard, which has been the standard under common law, again, as long as the common law has been practiced here. That's the standard of proof, is preponderance of the evidence. The at-will employment stuff, which I want to address, had been settled law in this state for 40 years. Missouri was an at-will employment state. There were some limited exceptions recognized by the Supreme Court in the mid-'80s, and there was very little that had interrupted that. There have been 6 or 7 published decisions, including 3 last week, that have fundamentally turned that law upside down. Now, is there all of a sudden been a big hue and cry in whistleblowers in the last 7 years, or has there been a change in philosophy to the chairman's question on the Missouri judiciary? It doesn't make sense. Worse than that, the judiciary is legislating from the bench in a way that is confusing and counterintuitive. The decisions don't even reconcile with each other. Just last week, the Fleschner case cited that Missouri exceptions would be if there was a clear violation of a statute, constitution, regulation, or the like, or a report of unlawful activity, or wrongdoing, undefined. I don't know what wrongdoing means. My clients don't know what wrongdoing means. Now, at that same day, the Margiotti court came out and said, no, it's got to be limited to a statute, constitution, or regulation. Didn't say anything about wrongdoing. Didn't say anything about a report of unlawful activity. It doesn't make sense.
This is about the 8th year that I've testified on this bill, and this time I apparently have some allies. And I represent Enterprise Holding, and we were one of the original companies that were burned by these court decisions. And we hope that the moving finger writes and having written moves on. And we hope that this time we will find the resolution to the contradictions and the confusion that surrounds this entire issue.
Have you ever had a case where you were denied discrimination because it was race and religion, and in your opinion that the would not be covered because it wasn't 100% race?
Yes, I've had what we call intersectional discrimination cases where I think a really good argument by a defendant, I hate to make their arguments for them.
Has there been a case decided, or you think is there just an argument that you're making?
There's been no case because there's no such standard as this until now, and I think the U.S. Supreme Court recently made age the determining factor. So, but the Age Discrimination and Employment Act, which is a federal law, is not the same as Title VII, and it uses different language. And they use the determining factor as opposed to a motivating factor for the rest of discrimination law. And I believe that there's going to be that problem now in age discrimination. Let's say it's an older black person who says I was fired because of my age and race. I think they will have that problem.
But there is current federal case law that says that it has to be the U.S. Supreme Court just said, I think within the past year, that under the Age Discrimination Employment Act, which is completely different from race, sex, religion, national origin, that statute, that it, because of the quirky language in the ADEA, that it has to be the determining factor. So there is case law that says in this area it has to be the, and there's questions on whether it should, in other areas it should be a.
No. In federal law, the Supreme Court made it clear, it is A for the whole gamut of employment discrimination law that falls under Title VII of the Civil Rights Title VII of the Civil Rights Act of 1964. But since the Age Discrimination Act was passed at a different time, and it's actually based on the Fair Labor Standards Act, it's very quirky. And so the Supreme Court said that under the ADEA's language, it's the determining factor.
Thank you. We heard testimony earlier that a motivating factor is sort of the prevailing standard. Have you practiced in multiple states?
Yes, I do. I practice a lot in Illinois, and I've practiced elsewhere.
Okay. Do you know of another jurisdiction where a contributing factor is the standard?
No.
All right. Thank you.
And for several years we have been supporting modifications to the Human Rights Act, particularly with regard to public employees, and we've heard a lot from the private employer side, and we concur in that testimony, but want to point out, particularly for our school districts, that this is an issue that we've been battling the last several years in school districts. The departure from the federal standard and becoming much more liberal in our interpretation under state law has caused us a great deal of difficulty in school districts as well, and some of the cases that you've heard about actually involve school districts. And so we are very supportive of the change and would ask the committee to push forward and want to note for the record our support.
Mr. Chair, members of the committee, Trey Davis representing the Missouri Chamber of Commerce and Industry, want to go on record in support today. Appreciate the Senator bringing this issue forward and appreciate the efforts of the legislation to try to send back a signal to folks that are doing business here in Missouri or want to do business here in Missouri that it's a good place to be.